Hi, everybody. Welcome to the podcast version of Constitutional Law 2, Civil Rights and Liberties. Over the last couple of classes, we talked about Fourth Amendment right against search and seizure and how to enforce those protections, mainly via the exclusionary rule. Having done that, we're going to move on to one of the components of the Fifth Amendment, self-incrimination. So we're still talking about the rights of the accused. Moving on to self-incrimination. So what I want to get through in the self-incrimination lesson is first, we're going to talk about really just the Fifth Amendment protections, but there's a little bit of Sixth that comes into play. And we're going to talk about how these rights came to exist, sort of how they were interpreted by the Supreme Court. And that's almost more important here than in any other area I can think of. Some people like to talk about judicially created rights. Well, some of the Fifth Amendment rights really are sort of judicially created. We're also going to talk about how they are implemented. That's actually the hardest part of talking about the self-incrimination protections. Implementation's really tricky, and you'll see what I mean as we go through this. So, the Fifth Amendment. Going back to the Fourth Amendment, talks about what police can and can't do when they're investigating, so when they're obtaining some sort of evidence. They have to obtain that evidence legally in order for it to be used in trial. Well, not all evidence is physical or material, so it's not, finding the drugs or finding the weapon or something like that. Sometimes evidence is verbal, or it's written down, it's testimonial. So something like a confession or a witness statement is in court sort of on par with that physical evidence, but the Fourth Amendment is what controls that physical evidence, and the Fifth Amendment is what controls, what offers protections for that testimonial evidence. So together, if you combine the Fourth and Fifth Amendments, at least the self-incrimination portion of the Fifth Amendment, those are the procedures for investigative agencies. That's what they have to use to gather this evidence and gather it legally. So what is self-incrimination? The relevant portion of the Fifth Amendment here is that no person shall be compelled in any criminal case to be a witness against himself. What that means is you cannot be required by the court, even if you're under oath, to say, yes, I committed this crime. Nor can you be required to say something along the lines of, yes, my friend so-and-so committed the crime and I was with him. Right, so self-incrimination also refers to incriminating somebody else that simultaneously incriminates yourself. You cannot be compelled to do that. You can do it voluntarily, of course, but you cannot be compelled to do it. So the self-incrimination clause of the Fifth Amendment is violated if the following two things are true. First, if this testimonial evidence is given and it incriminates the person providing it. And second, it has to be compelled, right? So like I said, you could do it voluntarily, but if it's compelled, then it violates your Fifth Amendment right. If a person gives a coerced statement, or a statement is deemed to have been coerced, that evidence is omitted. It's the same thing as the exclusionary rule for physical evidence. You can't use illegally obtained evidence, and it's illegal to obtain testimonial evidence through coercion. I encourage you to watch this YouTube clip. Just copy that URL and plug it into your preferred internet. Let's move on. So self-incrimination testimony. So there's a couple of things about it. So what this sort of looks like is that any defendant can refuse to take the stand altogether. But if they do decide to take the stand, they can refuse to answer certain questions. The sort of reason for this is that you can't force a defendant to choose between either incriminating themselves or lying under oath. Okay, so you can't force somebody into going to jail or doing something that might send them to jail, right? That's sort of, you can't put them in between the rock and the hard place. Another important thing is that implications regarding somebody's guilt cannot be drawn from their refusal to testify. So if somebody pleads their Fifth Amendment right, no conclusions can be drawn about whether or not they're guilty. That is not a signal that they're guilty. In fact, it's a violation of the Fifth Amendment right against self-incrimination. If lawyers suggest to juries that they should draw meaning from that, a judge will throw that case out or declare a mistrial or something if a lawyer does that. And the same goes for judges. Judges are not allowed to suggest that refusal to testify implies guilt. Another thing, the prosecution cannot threaten more severe punishment if somebody refuses to testify. So, if somebody's looking at 2 years potentially and they refuse to testify, the prosecution can't say, well, if you don't testify, it's going to be 4 years. That's a violation of the Fifth Amendment right against self-incrimination. You can't threaten somebody, with their job. You can't say you're going to get fired if you don't speak, or you're going to get fired if you do speak. This applies mostly to people who work for the government. Importantly, all of these things, all of these Fifth Amendment protections regarding not drawing implications about guilt and threatening more severe punishment, they apply beyond criminal trials, even though the Fifth Amendment is relatively specific about criminal trials. They apply to grand jury hearings, legislative hearings, and other things like this. Okay, so it's not just when you're sort of being brought up on charges in court. These rules are pretty clear, and violations of them are infrequent. So when somebody's sitting on the stand at their trial and they say they're not going to answer any questions, that's pretty much it. It almost never goes any further than that. Because of this, there are very few Supreme Court rulings on sort of this portion of the Fifth Amendment, or at least this sort of obvious, straightforward interpretation of it. What ends up happening is that most of the Supreme Court cases about the Fifth Amendment end up dealing with pretrial and interrogations. So when people self-incriminate before the trial or when they're being interrogated by investigators. This becomes important because, as we talked about, at what point does due process take over in the criminal justice procedures? A sort of hardline interpretation of the Fifth Amendment would be that it only takes over when you're at trial. So when you walk into the courtroom and everybody rises and they hit the gavel, that's when your Fifth Amendment right against self-incrimination kicks in. In that hardline interpretation, if you're being investigated by police before you've been charged, you don't have a right against self-incrimination. And the same goes for pretrial hearings. So sort of after, any sort of thing like bond hearings or things like that, arraignments. So a lot of times when this comes into play, these interrogation-based self-incrimination cases, it's really about police interrogations. In sort of the beginning, the court's always been kind of liberal on police coercion, or shutting down police coercion, that is. In a 1936 case, they said physical force cannot be used to obtain a confession. That's a violation of somebody's Fifth Amendment. In a 1959 case, they said you can't use psychological coercion. Okay. In the concurrence in that case, in Spano v. New York, they argued that attorneys should always be present to prevent coercive techniques. So that's sort of saying attorneys should be present. Now that kind of bleeds into the Sixth Amendment, but they should always be present to stop self-incrimination. So that sort of sets the groundwork for due process definitely kicking in before trial. From that concurrence stemmed two very important cases. The first is Escobedo v. Illinois. That question asked whether police have to honor the request for an attorney. Okay, and so this right to an attorney, it's sort of an amalgam of a couple of different amendments, but really it's about your ability to not self-incriminate. And then a case you're probably all familiar with, Miranda versus Arizona, that one dealt with how to enforce this right against coercion, if that right existed. So let's talk about these two cases in turn. So the first is Escobedo. Do you have a right to an attorney before trial? So this guy, Escobedo, he was arrested for murdering his brother-in-law. Police tried to interrogate him, but he didn't say anything, so he was released. They didn't have sufficient evidence to hold him. About a week later, Di Girolamo was in custody for the same crime, for the murder of this guy. He said Escobedo did it. Okay, so this time the police arrested both Escobedo and his sister, the deceased's wife. Escobedo said, I want to see my attorney, but the police said he couldn't. His attorney arrived, but he was not able to see his client. Escobedo was interrogated for almost 15 hours. He eventually made some damaging statements, meaning he incriminated himself, and then he was found guilty of the murder. His argument is that the statements weren't involuntary, so his statements that incriminated him were involuntary. And the reason they were involuntary is because of the circumstances of the interrogation. There were several circumstances that made the whole situation objectionable. First, police didn't tell him what rights he had. Second, he was being held incommunicado. That means he wasn't allowed to have communication with the outside world, particularly his attorney. There's a couple of other sort of circumstances here. He was underage, he was under 18, so that's sort of a factor, sort of easier to coerce youngsters. The interrogation lasted sort of a really, really long time. The police were being deliberately deceptive, so they were trying to trick him into admitting his guilt. He was also denied his right to counsel, even though he asked, and his attorney was actually in the building. He wasn't allowed to see him. So all of these things come together to make the statements coerced. So they're given involuntary. That means they're illegal. They can't be used as evidence. Illinois says these were voluntarily given statements. In between his first and his second arrest, remember, he was arrested and stayed mum one time, and then he was arrested a second time. Illinois says in that time, in between those two arrests, he consulted with his attorney, and his attorney told him to shut up, to not say anything if he was ever arrested again. But he did. He did say something the second time. So they're saying, it doesn't matter how old he is, how, what his mental capacity is. He potentially had some cognitive issues. But basically they're saying, ignore all that. He had advice to be quiet, and he went against his better judgment. So none of that was compromised. So this is all above board. Now here's really the crux of the argument. Escobedo's saying, hey, come on, I have a due process right here. I have a right to an attorney to sort of help me not self-incriminate. Here, Illinois is saying, yeah, the court says you have that right, but you don't have that right at arrest. When does your right kick in? Escobedo is saying it kicks in at arrest. Illinois is saying it kicks in at trial. So that's really the crux of the argument here. Illinois also says that nobody's ever said, no court has ever said that this right applies to the questioning after arrest. It applies at trial. It doesn't apply before that. So the question here is whether the police not letting Escobedo to talk to his attorney is a denial of his assistance of counsel in the Sixth Amendment. Now, you might be wondering why the heck we talked about the Sixth Amendment. Give it a second, it'll sort of be clear. The holding here is that, yes, that was a violation of Escobedo's constitutional rights to not allow him to speak to his attorney. So they have this thing, they're talking about a general investigation, and you don't have a right to an attorney in a general investigation, right? Because it's general, it's not focused at an individual. They say when the petitioner, Escobedo, asked to see his attorney and was denied, it was no longer a general investigation. They weren't just the police weren't just sort of looking for leads, right? They were trying to nail it down and get him to confess. When that's true, when it's no longer a general inquiry or a general investigation, Escobedo was the accused. And any interrogation, the whole point of it is to get him to confess to his guilt so they can wrap up the case and go to trial, right? So they're drawing a line between general investigation and when somebody's accused. They agree he has a constitutional right not to confess his guilt per the Fifth Amendment. They also say in the state, admitting complicity in a murder plot is as damaging as the admission. So it's like, oh yeah, I knew he was going to get killed, is the same thing as actually killing him. Escobedo didn't know this. And what he was eventually tried for and found guilty of was sort of the complicity in the plot. The interrogation, where he didn't sort of know this, the interrogation impacted the trial, right? So it's all about having a fair trial. That's what due process is about. And if the interrogation that happens before the trial muddies that trial, then one is being deprived of their due process rights. So what they say here is that Escobedo's ability to protect his rights begins at arrest. You don't have to wait till trial. They say we do not wish to preserve a system that relies solely on confessions of guilt. History tells us those systems fail and are subject to abuse, right? So they want an independent judiciary that's or a criminal justice system that doesn't rely on confessions of guilt. It relies on sort of police work and fact-finding and sort of stands up to the burdens of proof. Say any system worth preserving should not fear that if the accused is allowed to see a lawyer and become aware of and exercise his or her rights. So they're saying, what's the point of a criminal justice system where somebody is not allowed to know their rights and is not allowed to exercise them? What's the point of having rights if the whole point is, to not let people exercise them? So they say a denial of counsel is a violation of the Sixth Amendment when an investigation is no longer a general inquiry into an unsolved crime. So again, they draw a hard line between general inquiry and somebody being accused. So they say when an investigation focuses on a particular subject, if that suspect has been taken into custody, and if the police carry out investigations that lend themselves to eliciting criminal statements, so if they're trying to get somebody to admit guilt, if the suspect requests and has been denied the opportunity to consult with a lawyer, and if the police have not warned somebody of their absolute constitutional right to remain silent. So these are all examples of when the Sixth Amendment has been violated because an investigation is no longer general. Excuse me, these are all examples of when the investigation is no longer general. In these circumstances, if somebody's denied counsel, it's a violation of the Sixth. Again, why are we talking about the Sixth Amendment here? Well, it's sort of inherently wrapped up with the Fifth Amendment, the self-incrimination portion of the Fifth Amendment. So an individual has a right to not incriminate themselves. Well, having access to an attorney helps them not incriminate themselves, right? We are not required to be experts in the law to not expect that we will, or to expect that we will not incriminate ourselves when discussing things with police. White, Clark, and Stewart dissent in this case, and they say, why does this court seemingly want to bar all evidence from admission? That's hilarious to me. I love that line. They say, you know, look, now, after this case, the right to counsel makes it so we can't interrogate, so police can't interrogate the accused, right? The accused are the accused because there's some evidence that points at their guilt. And now we can't do police work to further investigate this by trying to elicit incriminating statements because of this right to counsel. Okay, this is such early attachment. What that means is the attachment of the right. So again, it's, you know, this right is attaching at arrest. You don't have to wait until trial. So they're saying such early attachment is unworkable and impossible to administer unless police cars are equipped with public defenders. Okay, so they're sort of saying, well, look, anytime that the police arrest somebody and they have their rights attached, you know, what if that guy's in the back of the police car spouting off about how he did it? And then he asks for an attorney, you know, is that admissible evidence? And I think they're sort of, the dissenters here are sort of taking, maybe building a little bit of a straw man, but their objections are warranted to some degree. Of course, this is just the first in several cases on this matter, so the ruling isn't particularly narrowed yet. Okay, so Escobedo created two major rules. The first is that the right to counsel attaches once an investigation is no longer general. So basically, once the investigation sort of settles on one or a few people, the right to counsel attaches. The second, any denial of the right to counsel after this period is unconstitutional. And again, the reason we're talking about this when it comes to self-incrimination is because this right, the right to counsel, helps preserve the right to not incriminate yourself. Again, the court relies on the Sixth Amendment here. They don't actually invoke the Fifth Amendment. They talk about self-incrimination, but they don't talk about it in terms of the Fifth Amendment. They imply that the denial of an attorney impacts self-incrimination. So the Fifth and Sixth kind of come together to protect you in interrogations. All of the amendments work together to protect rights. Now, the dissent was making the argument this is just from a practical perspective. This is really difficult, maybe even impossible to enforce unless you've got attorneys sitting in the back of the police car. Well, a couple years after this, the court came along with a way to try to enforce it. And that enforcement strategy is Miranda v. Arizona. Landmark case, one of the most famous cases. In this, so here's the story. Miranda allegedly kidnapped and raped a woman outside of Phoenix. Week and a half later, he was arrested and interrogated. He confessed after about 2 hours. There's no evidence whatsoever of police misbehavior, so they weren't hitting him. They weren't sort of, you know, it was only 2 hours. They weren't holding him forever. So the police sort of did it by the book. Miranda never requested an attorney, so this seems like a slam dunk case, right? Well, Miranda says, you know, I have a right to a counsel when I'm being interrogated per the Fifth and Sixth Amendment as determined in Escobedo. Providing that counsel doesn't handicap police in their ability to interrogate. A skilled interrogator can compel confessions from ignorant individuals who don't have that legal counsel with them. And they say providing legal assistance after a confession is of little help. What's the point? I mean, you've admitted your guilt. What's the point in even having legal assistance at the trial? You're going down for it. And Miranda argues that in order to reduce the inherently coercive atmosphere of an interrogation, police should inform suspects of their right to counsel. Right, so he's basically saying, I didn't know I was allowed to have an attorney. That's why I didn't ask for one. Arizona counters, and they say, well, come on, you know, nothing in this case justifies a constitutional rule that requires police to do this, right? this would be a huge constitutional ruling. It would have huge impact, and the proportionality is very sort of out of whack. What they mean by that is like the burden on the state is really high for sort of what might be minimal gain by rights holders. They also say, we don't even understand this complaint. His confession wasn't coerced. He was educated, he was emotionally stable, he understood what he was doing. So it's not even a claim about, we sort of took advantage of this guy. There's no brutality or psychological coercion, and the questioning duration was short, so this is all above board. So they draw a line, a distinction between Miranda's case and Escobedo, and they're saying he didn't have an attorney. Escobedo did, like he had one to call, he had somebody in mind, and he didn't ask to see one, so this is different. So Escobedo is potentially not the controlling precedent here. Because of this, because of these factors, the police didn't deny him his right to counsel. So he self-incriminated, and he did so seemingly in sound mind. So there's no fifth or sixth violations here. So the question is whether statements obtained from a defendant who's in custody, who's being interrogated, or in any way deprived of his or her freedom, are those statements admissible in court? And the holding is no. Those statements are not admissible in court. They rule in favor of Miranda. And they said, this isn't new. All we're doing is applying a long recognized principle to a new setting, right? It's been long recognized that somebody has the right to counsel. It's been long recognized that they have that right at trial. All we're doing here, all we did in Escobedo, is saying that that right extends to the arrest. It extends to the period when one was arrested. So that sort of your due process rights kick in at arrest. You don't have to wait until trial. Now, again, this case is really about the enforcement of that rule and making sure that people know about it and that interrogations are above board. So the court says, unless some other effective means are established, people who are doing interrogations have to do the following things. Prior to any questioning, a person must be warned that he or she has a right to silence. Any statement can be used against them. They have a right to an attorney, blah, blah, blah. If you've ever watched Law and Order, you know the whole thing, right? Those are called Miranda rights. A person has to voluntarily, knowingly, and intelligently waive these rights. It's not about invoking them. They exist. You have to waive them. Okay, they've kicked in once you're arrested. You have to waive them. Okay, it's not like, oh, well, we're going to sit around and if he doesn't ask for an attorney, we're good to go. No, you have to say, no, I don't need an attorney. Okay, they can be invoked at any time, right? If you've already started answering questions, that doesn't mean you can't then say, hey, now bring me my attorney, right? You don't have to finish answering any questions if you've already answered one or two. And the court's saying this is the only way, and importantly, they say, at least for now, that we can assure these rights. Okay, so I see this as being sort of similar to the Wolf ruling in the exclusionary rule instance. They're saying, there might be other ways to do this, and we think that those might be sound, but for the time being, we're going to use this one rule, so it's uniform, and we make sure all of the rights are sort of protected. Now here, as we'll talk about in a little bit, this is still the way we do this. There's never been an alternate solution that's been workable. So here they say, we affirm that the Fifth Amendment right to not incriminate oneself exists outside of a criminal courtroom. Okay, so self-incrimination exists. The right against self-incrimination exists, and it sort of kicks in at arrest. it exists anytime one's freedom of action might be curtailed. Right? Freedom of action means if you're arrested or even if you're just stopped by police. They say if we don't do this, if we don't have safeguards like this, people are just going to be compelled to talk. And even if it's not, via force or psychological manipulation or whatever, people might say things in circumstances where they wouldn't if they were in a different situation. This is true because there's an inherent pressure in an interrogation, and there's sort of an inherent power differential between a defendant, the accused, and police, and that's just a situation that lends itself to coerced confessions, even if the investigators aren't being actively coercive. They say the rules that are established are going to overcome this inherent pressure, this inherent power differential. The warning, the Miranda warning, is going to show individuals that interrogators are ready to recognize their privilege. That is, their privilege of not incriminating and seeing an attorney. They also say, look, FBI has been doing this for a long time. So if the feds can do it, so can states. This hasn't led to any lack of, criminal convictions at the federal level, so states should be able to do this too. White dissents with the same crew that dissented in Escobedo. And they say the court obviously distrusts all confessions. They say, well, how do we even conclude that the current way to determine which evidence is admissible is inadequate? What they're saying is, look, the courts all the time throw out inadmissible confessions. So what the majority is implying, or at least what the dissent is saying the majority is implying, is that why is that inadequate, and what evidence is the court using to say that that is inadequate? Why do we need a different rule? Why are we changing the current ad hoc rule for a per se rule, right? Ad hoc is case by case, per se is a little more general, and the dissent's not sure why they're swapping a system that's working for one that's sort of untested. They say this rule weakens the criminal justice system's ability to do its job, right? So it's going to be harder to interrogate people. They think the majority is trying to get rid of interrogations, get rid of confessions and guilty pleas, and increase the number of trials. There's any number of reasons that some judges might be doing that. It seems inconsistent to me with every judge's seeming desire to have less work to do, however. Okay, so after Miranda, we all know this speech when somebody's getting arrested on like NYPD Blue or Brooklyn Nine-Nine or something like that. Anytime police have you and you're not allowed to leave, even if you're not in the interrogation room, right, these rights kick in. Okay, so at arrest, or not quite arrest, anytime your freedom of movement is curtailed, these rights kick in. You have a right to not self-incriminate well before trial. And that's what these rulings in Escobedo and Miranda tell us. There's a power imbalance between the police and the accused, and that leads to problematic situations, even if active coercion is not undertaken. Right? So rights have to be safeguarded in these situations. So, to put it another way, you have these rights, okay, obviously. But when you're in a situation like an interrogation, those rights are a little bit weakened, okay, but they're not supposed to be. They just are necessarily by the circumstance. So these rights have to be sort of bolstered in these situations, right? So it's not like you're all of a sudden given this right, or this right takes sort of on a different form. It just needs to be built back up to the strength that it should be. The court argues that the Miranda rights, the Miranda warning, is the only way to do that. It's the only way to enforce these protections guaranteed by the Fifth and Sixth Amendment. Again, they say, for now. In 1966, this is how we're going to do it for at least a little while. And then we'll see what happens later on down the line. Again, I guess for now includes 2018 because they've never established another mechanism. This is still the way that the Fifth and Sixth protections are enforced in this day and age. So the dissent said there are some other mechanisms to ensure protections. It's not 100% clear what some of those might be. That's one thing I want you to think about, just as we talked about with the exclusionary rule. Do these sort of post-remedies work? The dissent is saying we've got these post-remedies and they're working just fine. Why do we got to go and switch it up now? The dissent also questions why they're switching from an ad hoc to a per se rule. I don't know about that. The court usually prefers uniform rules. They usually prefer the per se rules over ad hoc ones. Byron White was sort of known for preferring ad hoc cases more so than anybody else. The dissent also says the court's trying to make criminal justice more a part of the court system, right? So more often than not, a prosecution is done well before it gets to trial. The dissent accuses the majority of wanting more things to go to trial. I want you to think about why that might be. Take a look at the next couple of slides on your own. So as is so often the case, the Warren Court stirred up trouble, and then Earl Warren retired, right, and left it up to Chief Justice Burger, a more conservative shifting court, to sort of implement their decisions. Miranda's never been overturned, but it has been chipped away by these more conservative courts. Nowadays, it's almost applied very narrowly. There's been some exceptions carved out. So some of these notable exceptions are attorneys can use statements for narrow reasons other than incrimination. So if, let's say, somebody gets arrested and they say something to the police and then they invoke their right. So anything that they said to the police before they invoked their right cannot be used at trial to incriminate them. However, an attorney can be like, well, hold on, he said this to the police before he invoked his right, and that's proof that he's lying to us now. So they can use those statements for other reasons that aren't incrimination. Okay. Another one is that they don't have to be the police do not have to Mirandize if there is a public safety danger. So, police can run in and say, "Where's the gun?" And if somebody's holding it in their pocket or something, and they say it's in my pocket, and they're not allowed to have that gun, that's not having them self-incriminate, right? That's sort of protecting the public and removing the danger. Another exception is that references to attorneys must be clear. They don't have to stop, right? The police don't have to stop if a reference is ambiguous. Last year, there was a crazy example of this in Louisiana. Somebody said, "Give me a lawyer, dog." The Louisiana court determined that he was asking for a canine attorney. Yeah, that's pretty absurd. "Give me a lawyer, dog" is pretty clear. Now that I'm looking at this, there should probably be a comma between lawyer and dog to make his statement accurate with what he was asking. Another exception is that prior illegal police behavior doesn't nullify a good confession. So let's say the police enter your home illegally, they don't have a warrant, and they arrest you illegally. If you go and you get Mirandized and you confess, the fact that they came into your house illegally doesn't mean your confession is illegal, right? So prior activity that violates your due process right doesn't mean that confessions aren't good anymore. Let's see here. What do we got? Okay, let's finish up here on keeping Miranda. So Congress has tried to make Miranda warnings one of several elements that can be used, right? So like Miranda is a way to show that a confession was voluntary, right? If somebody was Mirandized and they confess, that it's voluntary. Congress tried to be like, well, okay, Miranda might work. Here's a couple of other ways that could also work. What that means is they tried to make it an optional practice, and they tried to establish other mechanisms. The reason for this is they were capitalizing on the court saying, well, Miranda's how we're going to do this for now. There might be some other ways to do it. Congress tried to come up with those other ways. In 2000, the court said, no, you can't do that. Even though in 66 we sort of said maybe, in 2000 in Dickerson v. U.S. they said, no, Miranda upholds the Fifth Amendment and the Sixth Amendment. Congress cannot statutorily alter that, right? That is our constitutional interpretation, and Congress can't use a law to change that. What they have to do is pass an amendment. Now, here's where it's so important. Chief Justice Rehnquist, who is a conservative justice, and of course Miranda is a very liberal ruling, the Rehnquist written majority said, look, we've narrowed Miranda over the years. We want it to be easier for police to conduct legitimate investigations, but Miranda is now a part of our national culture, and it's not going to go anywhere. Okay, so we're never going to get rid of Miranda, even if it makes sort of criminal justice just a little bit tougher. I think this is really important, and this is what I'll leave you with. Something becoming part of the national culture made it a part of constitutional interpretation. So for a lot of the hardline originalists, this is probably a pretty displeasing thing to hear, and I think it's important to have come from Chief Justice Rehnquist having written that. So I want you to think a little bit about how something like this, something that's part of our national culture, can actually influence how we interpret the Constitution and sort of influence what rights and liberties we hold dear. Okay, thanks for listening. This is where we'll pick up next time we meet.